Be ready. 5 seconds.
Both the central as well as the state government had no intent of collecting additional goods and services tax on the higher price, as they had sacrificed their revenue in favor of the buyer. Stop. By compelling the buyers to pay the additional goods and services tax on a higher price, the supplier has not only defeated the intent of the governments but has also acted against the interest of the consumer, and therefore, the goods and services tax collected by him on the additional realization has rightly been included in the profiteered amount. Stop para. In some cases, the petitioners have pointed out that the timelines as provided in the rules, 2017 have not been followed. Stop. They further contended that as a result, the proceedings are vitiated. Stop. However, it is important to note that the rules, 2017 do not provide any consequences in case the time limits provided thereunder lapse. Stop. As held earlier, the anti-profiteering provisions in the Act, 2017 and the rules, 2017 are in the nature of a beneficial legislation, as they promote consumer welfare. Stop. The courts have consistently held that beneficial legislation must receive liberal construction that favors the consumer and promotes the intent and objective of the Act. Stop. That being the scenario, it cannot be said that the proceedings as a whole abate on lapse of time limit of furnishing of report by DGAP. Stop. The Supreme Court in P.T. Rajan versus T.P.M. Sahir and others, bracket 2003, bracket close, 8 SCC 498 has held that, double quote, it is well settled principle of law that where a statutory functionary is asked to perform a statutory duty within the time prescribed therefore, the same would be directory and not mandatory. Stop, quote close, and that, double quote, a provision in a statute which is procedural in nature, although employs the word double quote shall, quote close, may not be held to be mandatory if thereby no prejudice is caused. Stop, double quote close. Consequently, the time limit provided for furnishing of report is directory in nature and not mandatory. Stop para. Section 171 of the Act, 2017 is widely worded and does not limit the scope of examination to only goods and services in respect of which a complaint is received. Stop. The scope of powers of the DGAP is provided for in Rule 129 of the Rules, 2017. Stop. From a reading of the said rule, especially the expression, single quote, any supply of goods or services, quote close, used in subrule bracket 2 bracket close of Rule 129, it is apparent that the scope of the powers is very wide and is not limited to the goods or services in relation to which a complaint is received. Stop. The word single quote any, quote close, includes within its scope single quote some, quote close, as well as single quote all, quote close, stop para. In any event, the ignorance of the consumer or lack of information or surrounding complexity in the supply chain cannot be permitted to defeat the objective of a consumer welfare regulatory measure, and it is in this light that the subject provision is required to be construed. Stop para. In the context of similar powers of investigation exercised by the Director General under the Competition Act, 2002, the Supreme Court in Excel Crop Care Limited versus Competition Commission of India, bracket 2017, bracket close, 8 SCC 47, has held that the Director General would be well within its powers to investigate and report on matters not covered by the complaint or the reference order of the commission, and an interpretation to the contrary would render the entire purpose of investigation nugatory. Stop.